Okay. Good evening, everyone, and welcome to the virtual campus talk on liberalism and the Indian judiciary with Mr. Alok Prasanna Kumar. The Center for Civil Society is hosting this virtual campus talk in collaboration with the Students for Liberty student chapter at the Faculty of Law, University of Calcutta. The Students for Liberty chapter at the Faculty of Law, University of Calcutta is a non-partisan network of students committed to expanding the ideas of individual liberty, freedom of expression, and rule of law. CCS is one of India's leading liberal think tanks, ranked 81 by the worldwide by the annual study conducted by the Think Tanks and Civil Society program at the University of Pennsylvania. The organization's work in the field of education, livelihood, and policy training is well known across the legal fraternity. It is an absolute honor to be able to collaborate with CCL. The virtual campus talk is part of the Indian Liberals Project and is supported by Friedrich Naumann Foundation for Freedom, South Asia. In this session, we will discuss the Indian judiciary's tryst with liberalism and the interplay of judicial decisions vis-a-vis individual and personal liberty. I request all participants to kindly switch off their camera and microphones for the entire duration of the talk. We will be sharing a Slido link for the participants to ask questions. I would like to invite Mr. Yazad Jal, Director of CCS Academy, to introduce our speakers and shed some light on the project.
Thank you so much, Ahana. It's a pleasure to be here at this campus talk at Calcutta University. So a quick thing about the Indian Liberals website. It's www.indianliberals.in, and it is a digital repository of the Indian liberal tradition, an initiative of the Center for Civil Society, and as you said, in partnership with the Friedrich Naumann Foundation for Freedom. So the website contains periodicals, magazines, podcasts, other various print and audio resources on liberalism in India, vis-a-vis its social, political, and economic manifestations historically. So you would find, for example, things on the Swatantra Party and Rajagopalachari's work, and work by B.R. Shenoy on economics, and a variety of fantastic resources. So I'd encourage everybody to go to indianliberals.in and check it out. Our speaker today is a friend of mine, and somebody I miss because I'm no longer in Bangalore. Alok Prasanna is co-founder and lead of Vidhi Karnataka. His research areas include judicial reforms, constitutional law, urban development, and law and technology. He has a BA LL.B. honors from NALSAR University and a BCL from Oxford in 2009. He writes a monthly column for the Economic and Political Weekly and has published, very widely in the Indian Journal of Constitutional Law, the National Law School of India Review, various media outlets like Hindu, Indian Express, Scroll, Quint, and Caravan. And of course, he is a practicing lawyer. He has practiced in the Supreme Court and Delhi High Court from the chambers of Mr. Mohan Parasaran, and currently also co-hosts a fantastic podcast called Ganatantra. So without much ado, let me give the floor to Alok Prasanna. Alok, it's all yours.
Thanks, Yazad. Thanks for that generous introduction. And hopefully we'll get to catch up in Bangalore soon once again all of this is over. But thank you for giving me this opportunity to speak to students about liberalism and the Indian judiciary. It's a fascinating topic. It's something that I think is ripe for what I'd say some disruptive thinking. I think there are far too many set notions and far too many easily accepted narratives that I want to slightly disrupt in the course of this talk. I'm not a political philosopher to question ideas of liberalism and liberty. There are people who already do that and talk about it from various perspectives. I'll just highlight some of the various debates. But what I hope to do during the course of this talk is to try and answer the question, is the Indian judiciary liberal? And I know the topic was chosen much before the events of the last 2 weeks. But it's worth sort of going over the events of the last 2 weeks. We saw that when Arnab Goswami's case came up before the Supreme Court heard it in an instant, literally like that. The case was filed, it was heard the next day. The court said personal liberty is too important to be allowed to be interfered with by the courts and so on. I mean, by the state government and court should act to save personal liberty. And he was granted bail in an abetment to suicide case. Now, the average person does not get this treatment in court. Let me assure you that. I have practiced in the Supreme Court for 4.5 years. You will spend many years trying to get your case listed in the Supreme Court. You will spend 2 weeks first getting your case listed in the Supreme Court and then getting what you want asked in the Supreme Court. The Supreme Court has said personal liberty is so important. So clearly thought that was a principle that they adhered to. But almost the very next day, or within the next couple of days, we have seen the Chief Justice of India observe orally, like with Justice Chandrachud in the Arnab case, where he observed personal liberty is so important. The Chief Justice of India say, we're trying to discourage Article 32 petitions. Article 32, which says that every citizen shall have a fundamental right to approach the Supreme Court to seek a writ of habeas corpus, certiorari, mandamus, basically anything which will go against government action which violates their rights. Now, for one day for the Supreme Court to say that personal liberty is paramount and we don't care about procedures getting in the way, we have to release this man. And on the next day, in the context of a journalist who was arrested by the UP police on allegedly spreading violence between communities when he went to report on a caste atrocity, to say that we don't want to interfere in this case, go follow the procedure, don't come to us seeking personal liberty. It seems to kind of confuse people. The simplistic answer that you'd want to draw is that, look, Arnab Goswami, close to the ruling dispensation, therefore gets this treatment of special treatment of having his case filed and listed and heard and orders passed in like a trice. Whereas if you are a journalist who is against the ruling dispensation, who wants to question the ruling dispensation, the courts are disinterested in your freedoms and your liberties and your interests. But to me, that's a simplistic way of looking at this. Firstly, because, it's two different judges, possibly they're taking two different views. Second, because it's just two cases, right? But it's two important cases, that cases in the public eye. And three, the Supreme Court is not the Indian judiciary. The point that I sort of want to make with this talk is that however we understand liberalism, there is a sense that we don't understand the Indian judiciary. Let me give you the story that most of us in law school and those of you who in law school are given. All right. This is the story of the Indian Supreme Court, which is passed off as a story of the Indian judiciary. And the story goes something like this. The story goes that in the initial years of the Constitution coming into force, the Supreme Court of India was favoring landowners, was favoring businesses as the government tried to carry out land reform, as the government tried to nationalize businesses. And the government responded by limiting fundamental rights. And this process went back and forth until some of the more egregious amendments to the Constitution took place. And the judiciary asserted that fundamental rights are sacrosanct, that they are part of the basic structure, that they cannot be amended out of existence, that the judiciary will always have the power of judicial review, and government can't interfere with it. This was the famous case of Keshavananda Bharati versus state of Kerala way back in 1973. Then, of course, came the emergency. A terrible violation where your fundamental rights under Article 19 and 21 was suspended. And suddenly the Supreme Court, which was so in favor of liberty, suddenly shrank back and said, no, when an emergency is imposed, we will not even offer remedy if the government, there's no remedy that you have, even if a constable were to pull out a gun and shoot a person, completely innocent person dead on the street, there's nothing you can do about it, too bad, right? So to have gone from one extreme to the other extreme sort of puzzled people, like what happened? And people drew the conclusion that it was possibly the Supreme Court which lost its nerve. Precisely because the high courts, right? The high court, which a lot of people had sort of, which sort of slipped out of the narrative in this picture, had sort of said that even during an emergency, nobody can be arbitrarily detained without the authority of the law. And even if they're detained, they will have recourse to the courts. 9 high courts across the country said that you will have recourse to judicial review. You will be able to question your detention, and you will be able to come out if the government cannot show. But the Supreme Court took a contrary view. Then you have the emergency being lifted. You have a massive election where Mrs. Gandhi herself lost and the Congress was defeated. And some of the more damaging amendments to the constitution, which affected fundamental rights and personal liberty, were undone to a certain extent, not fully. We know, of course, that the right to property was no longer a fundamental right; it was a constitutional right, and that was not reversed. But the Supreme Court seemed to be aware of its failing during the emergency, that the judges felt that we have to now restore the primacy of fundamental rights, and we have to now encourage more people to file the Supreme Court. You have judges like Justice Bhagwati, Justice Chandrachud, Krishna Iyer, D.A. Desai, Justice Chinnappa Reddy, all of whom took the view that we have to make the courts more accessible to anyone whose fundamental rights have been violated, whether it is under trial prisoners, or whether it is bonded labor, whether it is people living in polluted areas. And you had the era of PIL begin, and you had the court taking a proactive view in a lot of cases, going out there to effectively legislate in areas where the government had not legislated to protect people's rights. And this process continued until 2014, when the courts retreated, or at least 2015-16, when the courts started retreating in the face of a single party majority. In Parliament, you had a single party majority. The courts are now basically giving the government a free run to do whatever it wants. The cases concerning violation of personal liberty are not being heard, and you have instances like what I just described, where if you're somebody close to the ruling party, you'll get a free pass from the court. But if you're not, you will have to wait your turn. This is the narrative, right? This is the long narrative. I have condensed 70 years of Supreme Court history on India's history into about a 5-minute talk. But I want to question this narrative. I'm not the first person to question this narrative. For those of you who are interested in reading more and who want to read more about this, to get a sense of how this narrative has evolved, I would suggest that you read Working a Democratic Constitution by Granville Austin. It's a fantastic book, very well written, very engaging. But keep in mind, it has a particular narrative to tell. Not that there's something fundamentally wrong with it, but it's fundamentally misunderstood in certain ways. It's a great way of understanding how the Supreme Court as an institution has responded in certain ways. But you have to be careful about the conclusions that you draw from that book. Because the other book that I'm going to recommend is Anuj Bhuvania's Courting the People. This is a book which came out in 2016. It is based on Anuj Bhuvania, a good friend of mine, his PhD thesis, where he questions what was PIL all about. And he makes the claim that PIL was about increasing the powers of the court, irrespective of whether they improved the personal liberties or expanded the rights of individuals. That the rhetoric of rights, the rhetoric of personal liberty was used to expand the powers of the court, and more importantly, weaken procedure and restraints on the court's powers. And this has allowed courts to actually be responsible for some of the more egregious rights violations. And this is a controversial claim. In the sense of it upends some of the existing narrative that we have about the Supreme Court and the High Court, and makes you rethink a lot of the issues, that a lot of the stories that we are told in law school, and with something that we shouldn't be taking it for granted. So I would suggest those of you who are law students and those of you who are not law students also to read Anuj Bhuvania's book, because the narrative that I just told you, this is a book which fascinatingly critiques them. But this is just the start. And the reason why I say this is the start is because we have a very narrow view of what the Indian judiciary is. And I would have loved to do this exercise if I was in person with everyone. And unfortunately, it's the webinar format, and I can only just see pretty much myself and a couple of the organizers. But the image of what you think of the Indian judiciary, right? Tell me, if I ask you, tell me something that the Indian judiciary did in the last 1 week or 2 weeks. Most of you would have probably said this Arnab Goswami story, or the Prashant Kanodia story, or the Siddiqui Kappan story. And in a sense, what is revealing is that somehow in the public mind and in the discussion, public discussion, the Indian judiciary has shrunk to the Supreme Court of India. And I want to sort of, in the course of my talk, ask us to think of the Indian judiciary in a very different way. Let's keep in mind that the judiciary is this pyramidal body where at the apex you have Supreme Court of India, you have the high courts, and then by far the largest chunk of the judiciary, which is the unfortunately titled subordinate judiciary. They're not subordinate to anyone. They are also constitutional authorities in their own right. And in the course of this talk, what I want to do is go away with a different picture of the Indian judiciary, that the next time someone asks you about the Indian judiciary, you'll think about it bottom up rather than top down. That you will think of the Indian judiciary that 95% of this population, of India's population, actually interacts with, as opposed to that part of the Indian judiciary which 95% of us hear about. Okay? And this has important implications as I'll come towards the end of my talk. And I don't want to take more than about 40-45 minutes, because I want to leave at least 15-20 minutes for discussion. I don't want this just to be a one-way monologue. I want you all to sort of think about and perhaps critique or disagree with me or ask further probing questions of what I have to say. So I'll take about 40 to 45 minutes to speak about what I have to speak about the Indian judiciary is, and about whether the Indian judiciary is liberal, and then we can have a discussion about my part. Very briefly, and just to clarify at the outset, what do I mean by liberal and liberalism? I'm taking the most basic definition, and the most basic definition is something that Maurice Cranston says, and there's a fascinating for those of you who want a good introduction to what is liberalism and the various streams of thought within liberalism, do check out this Stanford Encyclopedia of Philosophy. You have a long article on liberalism, and it starts with this wonderful quote by Maurice Cranston, which says, "By definition, a liberal is a man who believes in liberty," right? Or if you want to modify it to say, by definition, a liberal is any person who believes in liberty. Now, does an institution believe in liberty? Now, obviously, an institution such as the judiciary doesn't have a mind of its own, doesn't speak on its own. It speaks through its various agents. But the Indian judiciary is supposed to uphold the constitution and follow laws, and laws made under the constitution, I mean. And the constitution that we have is, by any definition of the word, liberal. It incorporates even multiple, possibly conflicting ideas of liberalism. And the idea was never to have like the constitution is the last word on what it means to be liberal. The constitution talks about liberty of freedom, speech, thought, expression, ideas, and religion, and so on. And none of these we can assume are exactly the same for everyone. The constitution is also aware that it is not enough just to talk about negative liberty. The constitution is quite aware that in a country where perhaps the state was much weaker than society for a large part of its history, equality was inbuilt into the fabric of Indian society. And not just equality in terms of some people have more, some people have less, but structural inequality. That who you were born to determined pretty much the entire course of your life. That it didn't make any sense to say that you have liberty if society would never let you enjoy the true limits of your human capacity. So the constitution makers understood that. They understood that liberty is also about giving people that opportunity of doing what they want to do, what they would like to achieve in life. And that requires a completely different approach than to just say that your liberty will not be interfered with. So keeping in mind these ideas of, positive liberty and negative liberty, I don't want to go too much into it because the focus of my talk is not so much about competing theories of liberalism or which judges adopted what theory of it. My talk is to more focus on how do we make sense of the Indian judiciary as a whole, and how do we understand if the judiciary that we have is liberal in the sense of how much does it abide by the values of the Constitution of India, which espouses these liberal values. And it espouses these liberal values in a certain way, and it expects the judges and not just the judges, but the government also to abide by these values. So, keeping in mind this broad framing of the discussion today, to tick off on the Indian judiciary itself, if you think about the pyramidal structure, it is not a nice, smooth pyramid. You have the Supreme Court of India at the apex. There are supposed to be 31 judges. Immediately below them, in the sense that they don't report to the Supreme Court, but it's just that appeals from the High Court go to the Supreme Court, are the High Courts. At last count, there were 24 High Courts in the country. You have about 1,100 judges, or at least sanctioned strength of 1,100, but you have only about 650 or 700 judges or so. They are spread across the country. And then you have a much larger number of approximately 18 to 20,000, because the latest figures still haven't been collated and each state is in charge of its own recruitment, is the so-called subordinate judiciary. Right? This is the framing. This is just the broad framing. But keep in mind that if you were to add up the total number of judges in this country, and if you come up with a rough figure of 20,000, 18,000 or 90% of them, right? 90 to 95% of them will be judges at the subordinate judiciary. 3 to 4% of them, or maybe even 5% of them, will be judges of the High Court. And a small fraction of that, 31 judges of the Supreme Court of India, actually the most recent, 34, actually they increased the strength of the Supreme Court, 34 judges of the Supreme Court of India, they are not even 1% of the judiciary. It's like a fractionally a small number. So in this context, it should surprise us that when we say the Indian judiciary, that people automatically assume the High Court and the Supreme Court, right? And this is because there's a certain way in which we as law students sort of are taught the law, or even for that matter, how the judiciary works. And there's a certain way in which the judiciary itself is spoken about in public domain. And I don't want to say that's fundamentally wrong to talk about the Supreme Court or the High Court, or just because they have only a certain number of judges, we should be ignoring their work. What I want to sort of say is that we have to have a more nuanced understanding of the judiciary. We have to have a more deeper picture of what the Indian judiciary is and how it works. And in that way, when we frame questions such as this, is the Indian judiciary liberal, we frame it in a more precise way that will give us more meaningful answers. What I want to leave you today essentially is with more questions. I don't want to give you specific answers. And I believe first of all, it's not possible within the scope of a 40-45 minute talk to answer a question as broad as that. But also, if we don't change the way in which we look at the Indian judiciary, we will keep going around in circles, fighting yesterday's battles again and again, over and over, without really understanding how the institution works and what it is supposed to do. Now, coming back to the Indian judiciary, this three-tier way, it's not very understood what are the relationships between these three tiers. Okay. The High Courts don't report to the Supreme Court. In fact, many High Courts actually predate the Supreme Court of India. If you think about the Bombay High Court, the Calcutta High Court, and the Madras High Court, they were the first High Court set up in this country. And you had the High Court set up by the princely states, such as the Mysore High Court, the Rajasthan High Court, the Hyderabad High Court, the Jammu and Kashmir High Court, which were also set up pre-independence, and the later courts such as the Allahabad High Court, Patna High Court, Orissa High Court, and others, which were set up by the British in the pre-independence, which then got unified and merged into the Indian judiciary. So we have to keep in mind that the judiciary that we talk about today, what exists with us, has this colonial background. These were institutions which were set up to essentially replace whatever the existing mechanisms of justice delivery was there, was there in India. It's actually a fascinating history, and I don't think it has been fully explored. There are a few books about it. There is there is a volume about the Bombay High Court and its history by P.B. Vacha. There is one volume about Madras High Court and its history by, and I'm totally forgetting the author's name. I'll probably share it at the end of the talk if I can find some time. And we have recently, we have Abhinav Chandrachud, who wrote about the history of the colonial judiciary in India. But we don't really understand what it means to have a colonial judiciary. And it means that essentially the existing system of dispute resolution and justice delivery, right? They were, which was being run by various kings and kingdoms and so on, were rebuilt for the purposes of the colonial rulers. That you introduced a modern criminal law, which had the notion of procedural fairness and justice built into the text of the law. It wasn't about custom, it wasn't about caste, it wasn't about each religion has its own particular criminal laws. And I think that's one of the very interesting things that gets lost in the debate about this uniform civil code. That there was a contract law for Hindus, there was a contract law for Muslims. There's a separate contract law about how Hindus and Muslims had to sort of interact, and Jains had their own. So this was the history of pre-colonial India. But the present institution of the judiciary is descended from the court set up by the British for their purposes. And these courts were seen as reliable. These courts were seen as fair. These courts were seen, of course, they were expensive. We needed expensive lawyers to argue, but they were seen as neutral and impartial arbiters of the law. Not always, because we find that even towards the end of the freedom movement, people sort of mistrust the kinds of approaches that the courts take, the fact that they're willing to go along with whatever. But if you look at the actual Constituent Assembly debates, there is an admiration for the way in which courts function, that there is an admiration for the kind of rights that accused have in the Code of Criminal Procedure. And when we gave ourselves the Constitution of India, we didn't decide to toss out this colonial judiciary. The Constitution framers felt that this can be used, this is something that we can build and use for our own purposes. Modifications were made. There was a move to separate the executive and the judiciary at the third level, at the third tier of the judiciary, which is the subordinate judiciary. In the sense that earlier, even ICS officers could be appointed as district judges and so on. That was abolished. Fun fact, we have had a Chief Justice of India who never studied law, because he was an ICS officer who was appointed as a judge and from the ICS quota, became a High Court judge, became a Supreme Court judge, and went on to become the Chief Justice of India without ever having obtained a law degree. And this is Justice K.N. Vanchu, one of our finest jurists, and something to make you think about the appointment process, which I'll come to later. So when we sort of think about our judiciary, we have to keep in mind that this was a colonial judiciary which was sort of used, which constitution framers felt provides a working model for what we want in a under a liberal constitution, which guarantees fundamental rights and which guarantees personal liberty. And we believe this judiciary is capable of doing that. And it's not just the fact that they wanted a Supreme Court of India. There's a fascinating history also to why we have a Supreme Court of India. And it has to do with the success of the Federal Court of India, which was the predecessor of the Supreme Court of India. There's a there's a volume of essays called the Oxford Handbook on the Indian Constitution. In that one has one article by Rohit Dey on the Federal Court of India. It's a brilliant historical examination of a supposedly powerless court, right? The Federal Court of India is nothing like the Supreme Court of India. It heard barely 200 cases in its entire history of 10 years or so. It didn't have power. There were no constitutional fundamental rights at that point of time. But if you read Rohit Dey's essay, you will realize that even with the limited powers that it had, the Federal Court of India, it was in fact one of the first conscious defenders of liberty even during the Second World War. Even during the Second World War, it was holding the colonial British government to account, saying that you cannot deprive people of their rights to life and liberty without the proper authority of law, or offering justification as to why their rights to life and liberty should be deprived. Keep in mind that this Federal Court of India, which was saying this in India for a colonial country, was actually going dramatically against what the House of Lords in the UK itself was saying. In the UK, where you had a case such as Liversidge versus Anderson, where they basically said in times of war, there's no question of rights, there's no question of liberties. Somewhat like our ADM Jabalpur case in the Supreme Court of India. The Federal Court of India, with like a fraction of the prestige, a fraction of the powers, in charge of an admittedly colonial subject country, said that no, you as the colonial government still have to adhere to the basic principles of law and justice when you are depriving people of life and liberty. It's a fascinating essay, you should look at it. So, keeping this experience in mind, our constitution framers felt that we should have a judiciary which, although set up in the British times, will serve the purpose of a modern liberal order. What is the judiciary that they really created? Let's not start with the top. Let's start with the bottom. And when I say bottom, I mean the subordinate judiciary, which is an unfortunate name. It should really be the third tier of the judiciary. The third tier of the judiciary are your magistrates and your district judges, right? You may think of Article 32 when you talk about fundamental right to approach a court. There is, in fact, an article which also gives you a right to approach a court even without Article 32. And to me, that right is just as important, if not more important, than Article 32. Does not get discussed as often because we tend to take it for granted. Is Article 22, Clause 2. Article 22, Clause 2 says that when the police have somebody in their custody, they have to produce them before the magistrate within 24 hours. All right. And that you as an accused have a right to be defended by a person of your choice. Now, this used to be a provision in the Code of Criminal Procedure during colonial times. But the constitution framers actively decided to make it a fundamental right. I had an occasion to recently write about it for the Deccan Herald. I have a column where I write once a month. And I therefore claim that the judicial magistrate is in fact the most important constitutional functionary under the constitution if you want to defend fundamental rights, because any right violation by the government, when you're sort of taken into custody or when you're threatened or whatever it is, the fact that you have a fundamental right to be taken before the judicial magistrate can literally be a matter of life and death. I've explained this in the article, so if somebody could put up a link to it, you can have a look at it. But let's keep in mind that it was not just a Supreme Court, the right to approach the Supreme Court of India, which was a fundamental right under Article 32. This right to be produced before a magistrate is also as much an important right under Article 22 of the Constitution of India. So this is the first tier, or rather the tier of the judiciary that most people are likely to see first, right? This is the tier of the judiciary where all your immediate cases are filed. This is the tier of the judiciary you go to for bail. This is the tier of the judiciary that you go to for a criminal trial or for a civil trial or to enforce the contract. You have at the first level the munsif or the magistrate. They call different names in different states. You have the additional civil judge, and then you have the district judge. Now, within this third tier, there are three intermediate steps, but appointment to this is very different. It is the appointment to this judiciary is not directly through the executive. It is through a competitive process overseen by the High Court. Right? It's not as if the governor of the state can say X number of people will be judges. That the Supreme Court has clarified was not the intent of the Constitution. The governor has to, in consultation with the High Court, appoint judges to the third tier of the judiciary. Each state has its own procedure. Some have like a written examination and an interview, and Others have just a written examination and so on. But this is possibly one of the more open parts of our judiciary. States have also provided for reservations, which also means that people who are otherwise excluded from being part of the judiciary can write these exams and enter the judiciary. You only need to have generally between 3 to 5 years of experience to enter the judiciary at the lowest level. But and it also means that the person entering the judiciary at this level is someone in their late 20s or early 30s. In exceptional situations, even in their early 20s, there are people who can write the exam right out of their law colleges, and there are 23, 24-year-olds who've become magistrates in courts. So keep in mind that this lowest tier of the judiciary is composed of very different people from our Supreme Court judges. If you think about our popular culture, this never comes through, right? Those of you who have sort of seen Hindi films about criminal trials and so on, you'd be hard pressed to find a judge, even for a bail case or whatever it is, you'd be hard pressed to see a judge on screen who is less than at least 50 years of age. Whereas in reality, it's more likely that the judge you come before, or the magistrate that you come before, is somebody in their 30s or 40s and not in their 50s, or even for that matter, their 60s. So this is a very different generational gap between the lowest tier of the judiciary and the higher tiers of the judiciary. Their terms and conditions of functioning are controlled by the High Court. As a district judge, as a magistrate, like you, of course, as a magistrate, you report to the district judge. As a district judge, you report to the High Court. And it's the High Court which oversees their functioning. The same does not happen with the High Court and the Supreme Court. Judges of the High Court don't report to the Supreme Court. Whereas judges at the district judge level, they are assessed by judges of the High Court. Promotions are granted, or they may be disciplined accordingly. There's no way for the Supreme Court to discipline High Court judges. In that sense, it's not, the High Court is not subordinate to the Supreme Court in the same way as the quote-unquote subordinate judiciary is subordinate to the High Court. Okay, so this creates its own tensions and its own incentives. If you are a district judge, you have to keep the High Court happy, constitutionally. If you are a High Court judge, you're not really that concerned about keeping the Supreme Court happy, because the Supreme Court does not really control whether you are serving in this High Court or that High Court and so on. But all of this changed in the 70s and in the 90s. In the 70s, the central government decided to take a more proactive approach to appointing judges at the High Court and the Supreme Court. Whereas in the past, and this is something that is discussed in some detail in George H. Gadboy's book on the judges of the Supreme Court of India from 1950 to 1989, whereas up to the 70s, it was pretty much the Chief Justice of India who was consulted on the appointment of High Court and Supreme Court judges. In 71 onwards, the government decided to take a more proactive role and said, we will decide who's appointed. The Chief Justice of India can give suggestions and recommendations, but we will decide. Automatically, you find that High Court judges sort of are those who are in the good books of the government. Supreme Court judges tend to become those who are in the good books of the government. And this tension between the judiciary and the government stays unresolved well into the 80s. Till in the 90s, the Supreme Court of India says in a famous judgment, the second judge's case, that appointment of judges to the High Court and the Supreme Court will only be on the recommendation of a collegium of judges of the Supreme Court of India. Now, this particular collegium is composed of the senior most judges, and the government has no say in accepting or rejecting. They just have to appoint. If they have something which might make the judges reconsider, they should send it to the judges and say, please reconsider. But otherwise, the judges sort of have now given themselves the power to appoint other judges. It's been 26 years since this judgment was delivered. And in my view, it has been, whatever we have seen of it, it has been a disaster. The reason it has been a disaster is that essentially it has made the High Court subordinate to the Supreme Court. What it has done is that because the top senior judges of the Supreme Court of India are in charge of the procedure for not just appointment but also transfer. As a High Court judge, if you don't want your career to be damaged, if you don't want to have your ambitions to be a Supreme Court judge stymied, you have to keep Supreme Court judges happy. And this has fundamentally had a toxic effect on the way in which High Court judges exercise their independence. There is still a lot more research to be done on all of this, but this is some initial thoughts which has come out, and is something that sort of tells us something about the institution. You will see that there is a sense that High Court judges who want to make it to the Supreme Court will not upset the Supreme Court in any way. That they will quietly keep their heads down, not make waves, and they'll end up in the Supreme Court. We saw, for instance, recently, Justice V.K. Tahil Ramani of the Madras High Court in Tamil Nadu, who was suddenly transferred out of Madras High Court to the Meghalaya High Court, which is a huge change in like the press. It's basically like, I mean, no disrespect to the Meghalaya High Court, but it is not the Madras High Court. It's a bit like, being transferred from a plum position in like one of the larger states to have to go and handle a much smaller position in a much, much smaller state. And this basically takes out of the limelight. And it seemed to be some sort of a reflection on their unhappiness with her performance in some way. The worst part, it was never clarified what was wrong with what Justice Tahil Ramani had done, and she resigned in protest at this particular kind of treatment. But this is symptomatic of the fact that High Court judges have had to become subordinate to the Supreme Court judges. Now, you do find the High Court judges who sometimes take a different position, but they're doing it kind of at the risk of their careers. Keep in mind that when I talked to you about, when I mentioned the ADM Jabalpur case and the emergency case in the during the emergency, the 9 high courts where judges had said that even during an emergency, your fundamental rights are not lost, those judges got transferred out of their parent high courts into different parts of the country. It's reported that the stress of this kind of move, in fact, led to a couple of to at least one judge who died in the process. But they were seen as punishment postings. They were seen as you're being punished for the kinds of orders that you were passed. And what, unfortunately, the process of appointment having been taken over by the Supreme Court, sort of deciding whether people get to be High Court or Supreme Court judges, has meant that judges sort of kowed out to the Supreme Court. Why do I say that we have to understand the judiciary? Because we need to understand that when we are assessing the judiciary, we don't just end up assessing individual judges, which is where, to go back to the original example, when we sort of see that something is done in the case of Arnab Goswami, but not done in the case of Siddiq Kappan, it's not just about saying X judge is like that or Y judge like that. It's important to do it, but that's not where our inquiry should stop. It's one small part of our inquiry. And I think when we understand the institution at large and the specific acts of judges, we should be able to keep them separate and understand them separately, right? To go back to the original question that I started off with, what we really need to think about when we say, is the Indian judiciary liberal? We have to see it in, I think, very broadly, 3 different ways. One is, how often does the subordinate judiciary stand up to the police? How often, I mean, to give you an example of this, when the police ask for police custody, right, within those 24 hours and you're supposed to be produced before them, how often does a judge apply his or her mind and say, why do you need police custody? What is there to investigate? All the material is already available. Send them to judicial custody, which is to be an under trial. Or they would say that there is nothing in this case. No case is made out against this person. There's no reason to put them either in police or judicial custody and grant them bail. Because when a judge does not do this, it can actually be a matter of life and death. And those of you who are aware may have read about what happened to Jairaj and Benix in the Satankulam police station. One of the key things that is not or talked about often, not talked about enough, is that apart from the police brutality involved, the fact that they were produced before a judicial magistrate who couldn't be bothered to ask them, why have you been arrested? Who couldn't be bothered to ask the police, on what grounds have you arrested them? Why do you need police custody? Or even ask them, are you being treated well in police custody? Why are you limping? Have you suffered any injury? But just simply said, which police station? What do you want police custody? Granted. Right? When magistrates function like that, it is not just about affecting one or two. This is something that you're talking about 95% of the judiciary. If they approach their tasks in this manner, the fundamental rights of all of us are in danger. This is how we have to think about this issue. So how often does the subordinate judiciary actually hold the police accountable is something that we have to think about when we want to answer the question, is the judiciary liberal? The second question that I want to sort of break up into is, how often do high courts stand up against government intrusion of liberty? Keep in mind that most of the time, laws made by the state or the central government are challenged at the high court level first before they go to the Supreme Court level. We have to see how often, and not just in terms of making a big law. Some of you may be aware that Kerala has recently passed a law which has this vague restriction of freedom of speech on the internet. It's first going to be challenged in the Kerala High Court. It's not going to come to the Supreme Court. Maybe it might come in a few years, but it's the first challenge is in the High Court. And how do high courts address these kinds of challenges? How do high courts even go into questions of bail, anticipatory bail? How often do high courts demand that, exercise their power of habeas corpus and demand that people in police and judicial custody be brought before them? This is how we have to think about the high courts and their function, because that is what they're supposed to do. The high courts have been, in fact, given much more wider power than the Supreme Court under Article 32. High courts have an equivalent power under Article 226, but this power is much wider, and the intention was anyone aggrieved by state action would go to their nearest high court first, not necessarily the Supreme Court. Finally, when we address the Supreme Court, we should think about the Supreme Court and its interpretation of the Constitution. Too often, the Supreme Court's work is caught up in very mundane kind of cases. And I think that doesn't really tell us too much about how liberal or otherwise the Supreme Court is. But we need to sort of make the Supreme Court do its constitutional function, which is to interpret the Constitution. Because the Supreme Court is the final arbiter of interpreter of the Constitution. Yes, high courts can also interpret the Constitution, but the Supreme Court which has the final say. And when we're talking about how liberal the Supreme Court is, we shouldn't be so caught up in this case they gave bail, in that case they didn't give bail. We have to see how have they interpreted the Constitution and how is that at a downstream. So to sum up, and I'll stop here so that I can take your questions. To sum up, when we ask the question as to how liberal the Indian judiciary is, or whether the Indian judiciary is liberal, we have to break that question down into multiple components. It cannot just be that we look at what the Supreme Court does and come to a conclusion. It cannot just be that we look at only Supreme Court judgments. I mean, it's important to read judgments, it's important to critique them, but we should know which ones to look at and how to critique them. And I would say that when looking at the subordinate judiciary, we should start thinking of more detailed, data-driven, empirical research into understanding the judiciary. That's been happening in the last 5 to 10 years or so, but that is like catching up for 60 years worth of non-action. I think what I want to leave you all with, if I have to leave you with a call for action, is to say that the Indian judiciary, given its importance, is vastly understudied. And any question that we pose about the nature of the Indian judiciary will open up so many areas for research and thinking and writing that anybody who does it is probably going to be a pioneer in their field. So to sum up, I sort of want to leave you with these questions and ask you that perhaps if you ever think about doing research, if you want to ever think about writing about the Indian judiciary, think about proceeding along these lines and think about framing your questions such that whatever answer that we eventually get is something that gets us closer to the truth rather than just accepting a convenient narrative. Thank you.
Thank you so much, Mr. Alok Prasanna. I think the fundamental misconception that we are sort of taught in law schools more often than not has been quite cleared now. And we have a flurry of questions for you. I'll read them out for you. The
Sure.
first question that we have is that now this is pertaining to the Indian higher judiciary. The question the person has asked is the Indian higher judiciary, that is the Supreme Court, currently too big? Should we have a smaller Supreme Court?
I'll pose a more heretical question. Should we have a Supreme Court? Right? Because the size is also dominated by the kinds of cases that come to the Supreme Court. I recently gave a talk on do we need a Supreme Court of India? And my point is to say that maybe we need an apex criminal court, we need an apex civil court, and we need a court of constitutional interpretation. And also a court for federal disputes, which can be the same thing given our federalism comes from our constitution. Instead of one Supreme Court, we may need three different courts. So I will reframe that question to say, instead of whether the present Supreme Court is big or small, whether do we need one Supreme Court is the question that I would ask. And my answer is we don't need a Supreme Court. We don't need a Supreme Court. We probably need three different courts.
Thank you for that. The next question that we have is, how much of the current method of self-regulation of the higher judiciary is impacted by what had happened during the emergency era?
I'd say it's tough to draw a very neat causal relationship. Because between the events of the emergency in the 1970s and the second judge's case in 1990, there has been more than 20 years, approximately 20 years have passed. It wasn't as if the emergency was lifted and the court said, that was terrible, we should do something about it. It's hard to draw a neat parallel because what happened in the 80s is also something I have to keep in mind. In the 80s, you had repeated clashes between the judiciary and the executive over a lot of issues, including appointment of judges. The proximate trigger for something like the second judge's case was the fact that the government just refused to appoint judges. It simply said, my way or the highway. But also keep in mind that 1994 is important because you've had no longer have, it's been 5-6 years since the first, since a single party majority has been in power, right? Judges have tasted blood. Judges have realized we have an opportunity to reclaim some powers for ourselves because the central government is going to be weak for a while. And that's when they went for it. So it's a combination of factors. I don't believe in one thing playing a role in the other thing. I mean, something as big as, say, Supreme Court's approach to it, especially if that's a time period of about 15, 16 years. Because keep in mind, there was an attempt to use the experience of the judiciary during the emergency in the 70s and 80s. The first judge's case is the Sankal Chand Seth case. There was an opportunity to rectify it. They partially rectified some of the problems that emerged during the emergency, but it was a time, it needed the right set of circumstances and time before the second judge's cases happened.
Thank you for that. The next question that we have, considering that the High Court are not inferior to the Supreme Court judges, should Supreme Court collegium in any way have power over promotion and transfer of High Court judges? And what would be the alternative?
I've already said that in my talk. They shouldn't. The alternative, I think, is to create a body which actually looks at appointments, a commission of some sort. I don't mean the National Judicial Appointments Commission, which was passed and struck down. That was just a collegium by another name. It's not any different. I'd want a body where judges, the government, and civil society are equally represented. There's such a body has existed in other countries. The UK has one. And no one particular part of these three groups should have a dominant say in this. I think it's possible. It should be that no one sort of gets to control this body. And I would say that that is a more better state of affairs. Pakistan also has such a body, by the way. It's something that we can look from around the world and see what might work, because definitely the present system that we have is proving to be a disaster.
Our next question is, does this system of subordination of different courts and the string being tied in top-down hierarchy, defeat the purpose of justice at large?
Not necessarily, because the hierarchy works in the terms of giving you a shot. If something goes wrong at the first time, you have a shot at taking an appeal. If you get an unfavorable order, you can file an appeal. You can expect justice to happen. So justice gives you that opportunity to say you can go up the judicial hierarchy. But it also creates this kinds of perverse incentives where independence may be affected. And that might affect justice. Where if you feel that you have to constantly watch your back as to whether you're doing a good job or not because of the case in front of you, or because of a standard set by the High Court. If the High Court says, I expect you to function in a certain way, but doing justice requires you to function in a different way. And if you're constantly watching your back, that affects your independence. So yes, in that sense, it could affect the delivery of justice. But I would say that it gives and it takes. So it's not something that has a definitive answer.
Thank you for that. The next question, and is the Indian lower judiciary liberal? That is the question that the author has posed. Or is it more procedural without application of mind or elements of liberty by judges?
That's a great question, actually. That's an excellent question, and I think it needs to be researched. I think there is room for someone to say, I will look at all the orders of remand passed by one court in Delhi and see how many were justified, how many were not. How many of them eventually got bail? In how many cases did the trial collapse? In how many were the charge sheets quashed by the High Court and so on? And see how often does the judge apply his or her mind. Judges are supposed to apply their mind. Even for something like remand, they're not supposed to give it mechanically. But a lot of times they do that. How do we ensure that they exercise their mind? This is where the High Court can play a positive role. This is where the High Court can say, I won't look at your big judgments, your big 5,000-page judgments, convicting or acquitting someone. I will look at how many cases came to you for remand. How many, and of these cases, how many cases does it look like you've applied your mind to it? How many cases have you given reasons for remand? If High Court start looking at such questions, judges will start applying their minds. And to go back to the previous question, when judges feel, okay, only my big judgments, looking at evidence, looking at material, all of that is only what's going to be assessed every year if I have to get a promotion, they will focus their energies on that and ignore like past orders of remand mechanically. But if High Court were to say, I will look at both, you will see a very different pattern from judges. So which is why I do believe, one, there is great scope for research. Somebody should please take up this project. And two, the way in which the High Court sort of assesses the subordinate judiciary has a role to play.
Thank you. The next question is sort of pertaining to the previous question, and you have answered about whether we need a Supreme Court at all. And the question here is, does India need a Supreme Court as a court of appeals? Or would a Supreme Constitutional Court, which only looks at constitutional matters, work better for India?
See, because High Courts also address questions of constitutional importance, any court, any apex court, let me call it that, any apex court which is in charge of interpreting the Constitution will have to hear appeals. Will have to hear appeals from the High Court, because two High Courts may genuinely take two different views on the constitutional text. And you can't say that too bad, it's going to be that way. You have to have some forum to address any conflict. So when I earlier spoke about my idea of a apex court of civil cases, criminal cases, and constitution, this will be a court which, of course, there will be the fundamental right under Article 32. It will address center state disputes, and it will also address, of course, you can approach it directly to interpret the Constitution, challenging basic structure, etc., etc., and appeals from High Court, where the High Court has interpreted the Constitution in a certain way, as opposed to like a purely civil or a criminal case. If there is a case concerning the interpretation of the Constitution, Supreme Court should, this apex constitutional court should hear such cases also.
Thank you for that. The next question is sort of something that you've been talking about you've talked about in your article in the Deccan Herald, the reduction of the importance of judicial magistrates Is it via political design or merely incidental?
It's incidental. I don't think it was meant to be by political design, because the constitution framers were very aware of how important this particular office was. The fact that there is like fundamental rights, um, and the fact that this was an opportunity for states to access to sort of reserve seats and so on, shows that they didn't ignore it. They knew the importance. States have framed rules, states have provided for reservations, and not just reservations on caste purposes, but also reservations for students from rural backgrounds, for lawyers from rural backgrounds, reservations for women, reservations for ex-servicemen, person with disability, whole category of reservations. States are interested in this, but it's just that we tend to focus, like, if you ask, and I want, this is what I want to do this exercise for. If I sort of asked people in the room, who is the Chief Justice of India, 95% of them would know. If I ask them who is the Chief Justice of the state in which they're from, maybe 50-60% would know. If I ask them who is the district judge in their district, 100% of them would not know. I'd be surprised if even a single person did. But that, is something that our discourse about it has sort of meant that we have been blind to the third layer of the judiciary. Even though it's possibly the most important, most widespread, and most used part of the judiciary, we focus on the glamorous parts of the judiciary, the High Court and Supreme Court, not so much the subordinate. And it's a complex set of factors which have gone into play. It's just that over time we've neglected it, and I think it's time to stop that.
Thank you for that. So the next question is similar to the High Court judges falling in line with the Supreme Court judges. Can something be done to stop Supreme Court judges from seeking potential post-retirement benefits from the government?
Yes, a constitutional amendment. No, in all seriousness, there's this fantastic, and if you can just put that in the link, I'll be grateful. There's this fantastic research paper called Jobs for Justice by 3 scholars from Singapore, who talk about how Supreme Court judges, towards the end of their careers in the Supreme Court, start favoring the central government in important cases. It's a very well-researched, very rigorous paper, uses econometric methods, and it's fascinating. It's really well-done research. And the conclusions are fairly clear. There is a definite trend that you sort of see in that. And those of us who were in the system had anecdotal evidence for this, but this research by Madhav Ane, Giovanni Ko, and others have sort of clarified for us this with solid numbers.
Thank you for that.
But I mean, the short answer is to have a constitutional amendment which says that we will raise the age of retirement of the Supreme Court judge to 70 years. No appointment under any central or state government unless it is approved by all the judges of the Supreme Court.
Thank you. We'll have 2 more questions before we run out of time. And the next question is in reference to leaving the Supreme Court to its original function of constitutional interpretation. What are your views on application of the Puttaswamy principles in the Aadhaar case?
Just one quick clarification. The Supreme Court's initial work was not only constitutional interpretation, because they gave the Supreme Court this special leave jurisdiction. The special leave jurisdiction was something that the House of Lords had, and they felt the Supreme Court of India should have, which was also supposed to apply to regular appeals. So let's not confuse original intent with what should be, right? What I'm saying is the Supreme Court's scope should be just constitutional cases, whereas the original intent was not necessarily so. You do find the Constitution giving the Supreme Court civil and criminal jurisdiction, so let's not confuse the two things. In terms of Puttaswamy and Aadhaar, I mean, talking about the 9-judge bench into the 5-judge bench case, I think it is quite, first the 9-judge bench, because they didn't have a specific fact to decide upon, judges have said all sorts of things. But when we come down to the 5-judge bench case, it's a very confusing judgment. My sense is it was a judgment written in haste. They needed to decide, are these clauses of the Aadhaar Act valid, invalid? And they just found whatever. If you actually read through the judgment, it is quite incoherent. The reasoning in the 5-judge bench case, specifically looking at the constitutional validity of the Aadhaar Act and its use in various contexts, it is not very coherent. And I think some parts of it are already being re-examined. Some parts of it will have to be re-examined. But in my own view, the principles laid down in the Puttaswamy case, they have been muddled up very badly in the 5-judge Aadhaar case. And that is where we stand right now.
Thank you for that. My final question is pertaining to what you have been talking about, the role of the judicial magistrate. And the question is, considering fundamental rights are more often defended before magistrates, should they be held liable if they act in the manner the magistrate in Tamil Nadu acted?
I completely agree. I think that there are proceedings ongoing. When the inquiry report comes out, I hope that the report says that the magistrate completely failed in doing his duty and should be disciplined. Therefore, I do think that, I mean, there can be right and wrong, right? There may be a magistrate who tries his best but cannot do something. Obviously, for instance, if the police manipulate their registries to show that somebody was arrested later than they were actually arrested, there's not that much the magistrate can do. He can only do what he can within the scope of his courtroom. But even if within the scope of his or her courtroom, if a magistrate is negligent to the point of not caring about whether they're doing their job or not, I think that requires some very serious action on the part of the High Court. I think that is where High Court should exercise their powers of superintendence over the subordinate judiciary and send a message saying, just do your jobs, right? We want you to do this because this might be the most important thing that you do. Yes, writing your judgments is fine. Yes, correcting evidence, etc., is all good. But this might be the most important job that you do. And I genuinely hope that the Madras High Court sets an example in this particular case to say that this particular magistrate will be disciplined for his abysmal failure of duty.
Thank you very much. With this, we come to the end of the Q&A session. I'd now like to invite Ms. Ahana Bag for the vote of thanks. Ahana, over to you.
Hi. Thank you so much, Mr. Alok Prasanna Kumar. That was an amazing discussion and really eye-opening. This is not how judiciary is usually portrayed in law school or in the, as you said, this is not the more glamorous side of judiciary, and many law students, myself being one, we don't aspire to necessarily be a part of the quote unquote subordinate courts. We rather want to be a part of the High Court and the Supreme Court, and that is how we think that we will be able to make a difference. So this part of your narrative that 95% of the population actually does not interact with that court is absolutely correct, and it really changes our perspective, and at least mine, to say the least. For the participants, thank you so much for tuning in, and we will share a feedback link. It already has been shared in the group, and I would request all of you to please fill it up. On behalf of the chapter, I would like to express our thanks to the Center for Civil Society for choosing to collaborate with us on this, and our gratitude to Alok sir for having this amazing discussion. We would also
Thank you so much, Alok.
Thank you so much. It was my pleasure to speak to you all, and it was a great interaction. And I hope we can do this soon often.
Thanks a lot. Thank you. Sorry, you can stop the live stream for now. For the participants who are here, it'll be great if you can take a minute to fill the feedback form for us. And thank you for joining us, and have a good evening.